This Honorable Court of Appeals of Tennessee is in session. Please be seated.
Good afternoon and welcome to the afternoon session of the Court of Appeals. We're delighted to be back with you in person, and I hope you're delighted to be back, as we are. Your panel this afternoon will be Judge McGee from Savannah, Judge Armstrong from Memphis, and I'm Judge Golden from Memphis. I'm sure all of you who have been here before know that how this works. We have a timer up here. Each side's entitled to 15 minutes. The appellant can take up to 5 minutes for rebuttal of their 15 minutes. You just need to request the amount of time up to 5 minutes that you would like to keep, you would like to have set aside for your rebuttal time. Of course, the appellee is entitled to their 15 minutes with no rebuttal time. Madam Clerk, do we have any announcements or anything else we need to address?
No, Your Honor.
Would you please call the case?
Harold R. Gunn versus City of Humboldt.
Well, please, I'm Harold Gunn from the Humboldt Bar. I'd like to reserve 2 minutes.
All right, sir. 2 minutes.
This case is about a drainage ditch, and the question is, whose job is it to maintain a drainage ditch inside the city limits? This issue is one that no one wants to answer. However, sewage problems have been answered. The city maintains the sewage, not the citizen. The citizen has to tap on to it from the street to his house, but it's maintained not by the citizen. The utility board comes along and they put up lines, and the citizen doesn't have to maintain that. It's been ruled many times that it's not their responsibility. Case law here talks about a natural flow rule. And the natural flow rule says that if anybody hinders the natural flow, then they're responsible. In this particular case here, I never hindered any natural flow. The other case law talks about the police power. The police power covers a lot of things, but they also use it to cut the weeds in a drainage ditch so it flows better. But what we have here is the trial judge rule that the Governmental Tort Liability Act prevents all that. It's my land and my responsibility. Now, I don't see how it's my land, but I don't have the machine, the know-how to maintain a drainage ditch. This particular drainage ditch is like 15 feet deep. And a culvert popped up that the city placed, and it eroded my drive to this building that I rented to this collision specialist for 32 years. And I didn't do anything to the ditch. So what we have here is the city put in a dam, the city put in culverts, and when they fail, they say, oh no, it's your responsibility under the Governmental Tort Liability Act. And it reached a point that if they're not going to fix it, I file suit for them to fix it. I feel it's not up to me to fix it under the natural flow rule, under the police power, even under the Governmental Tort Liability Act, because it was a nuisance. It kept doing away with the drive, and I'm saying, fellas, this took place in July, and the trial was in December. Why didn't y'all do something from July to December? I, as the owner of the property, did nothing for 32 years to the drainage ditch, and it flowed fine until these culverts popped out, and then consequently, it flooded, eroded my parking spot to the buildings, and the only thing I can say is hopefully this court can answer this question. Thank you.
Good afternoon. Michael Bill from from Milan, representing the city of Humboldt. Mr. Gunn has a business that has a auto body shop on it. On this business, if the business is here, the parking lot runs next to that, and then there is a ditch that runs entirely on Mr. Gunn's property and also services a piece of property that's behind. It goes underneath a state route, US 79 in Humboldt. Then it drains along Mr. Gunn's property to the two properties that he had. The proof at trial, based upon some of Mr. Gunn and based upon his renter, indicated that there's like underneath his driveway parking lot, there's like a box culvert that drains the water that goes underneath the state route, comes along his property, and then drains off the back of that. There's a box culvert that was, and above was encapsulated. Mr. Ellis, who is his renter, testified that encapsulation occurred many years ago. There was no testimony that the city encapsulated this parking lot. In the drainage structure, there is also a big, you'll see in the record, terminology of a cylinder. It's a large cylinder that is right on Mr. Gunn's property line and also on the property line of a bank that's there. Water would then come off the parking lot to the adjoining bank, go in the drainage structure, go through the ditch, and then drain. Mr. Gunn refers to a dam. You'll see in the record that dam is a head wall. There is a head wall that a pipe ran under to drain the water out. Again, there's no proof in the record that indicates that the city built that head wall. Don't know who did it, but the city did not do it. Now, there was a drainage problem at one time, and the city came out and based upon Mr. Ellis's request, and in this cylinder, it had a drain at the bottom of the cylinder. That somehow got stopped up. The city came in and put a black plastic culvert piping, whatever, where that water would drain out at the top and then go to the head wall and go underneath that. And they attached a silver pipe to go with that. Mr. Ellis testified that after the city did that, everything drained properly. Okay, so the only thing that anybody ever testified to what the city may have done was to put in this one pipe in this cylinder, and then Mr. Ellis testified that thing made things good. Then in the summer when this happened, Mr. Ellis and one of his other workers testified that there was substantial rain during that period of time, and it started collapsing. Mr. Gunn indicated that he had no warning that the property was going to collapse because the parking lot collapsed, and a part of the ground collapsed that there was no parking lot. And that's what Mr. Gunn wanted the city to fix, because his theory is because we put in the pipe, that meant we had a duty to maintain his property. There's no evidence that the city owned this. The city did not have an easement across his property. They did go and put out a pipe, but as I said, Mr. Ellis said that made things drain better. The court agreed with me that based upon him asking for damages against a governmental entity, he would have to show that they owned and controlled the property. That's been long-standing law that if you go sue a governmental tort under the Governmental Tort Liability Act, you've got to show ownership and control. He tried at trial to maintain a nuisance theory, but Judge Akery said you didn't assert a nuisance theory until trial. Even if he did, and this thing works with both his theory that we maintain it and even if he did assert a nuisance theory, the biggest problem that he has, if he can even get past the ownership and control to get to damages, he has no evidence that anything that the city did is what's caused the damage to his property. The only thing he testified to at trial, to the trial court, was, well, it's just common sense. Well, when you're talking about a collapse of a drainage structure, I don't think common sense carries the burden that you need to demonstrate that something that the city did caused this. And you'll see, and I quoted in the brief, and I mentioned just a minute ago, there's this cylinder where the water comes in, and both, I think Mr. Gunn, I know Mr. Ellis testified that water for years had been dumped into that cylinder, into that drainage structure and collapsed. That alone could account for the collapse of the drainage structure. There was also, I had Mr. Ellis admit that during the trial that where over this encapsulated culvert, there's a parking lot and then it goes to dirt that's just covered. There were cars parked in that area for years, exactly where this collapsed. That again could account for why this happened. Mr. Gunn has no evidence whatsoever as to the cause of this. He didn't call an expert, so there's no proof whatsoever that even if this court felt like that the city had a duty to maintain it, which it doesn't, but even if they did, there's still no proof that anything that they did is what the cause of the collapse was. So the city does not have a duty to maintain a drainage ditch on his property. Again, it's like I said, the water that runs under the street is a U.S. state route anyway. The city can't control that.
Is there a transcript of the testimony in
I believe it is. I know somebody testified that, you know, this goes underneath a state route. I think Mr. Ellis may have
But there's a
agreed to
transcript
that.
of the testimony?
I believe so. I don't know exactly where it is. I think I mentioned that in the brief, but I'm not positive.
No, but what I'm asking you, is there a transcript of the testimony?
Oh,
of the
yes.
trial?
Yeah, that's correct. Yes, I'm sorry. Yes, it is. Mr. Gunn also said that the court erred in cutting off his ability to testify as to damages. Well, Mr. Gunn, of course, being an attorney, represented himself and took the stand and testified. At the end of his case in chief, I asked for a directed verdict. How he thinks that the court cut off his ability to provide damages, I don't know, because I asked for the directed verdict, of course, after his proof. So if he had additional proof that he needed to submit it, he should have done so during his case in chief. The only thing he did was pull out a number and said, my damages are $72,000. Didn't explain how he got there. Didn't even really say that that was a diminution in value. And I would submit that with this being property damage, he needed to show cost of repairs before you even get to diminution of value. He did not provide any evidence as to the cost of repairs because he doesn't have any. He submitted the real estate data assessment for the value of his property, said it was, I forget what it was, but he put that number in, and then he had the real estate data assessment and the deed for the adjoining property. Now, I don't know how those two values have anything to do with what he's alleging as to damage to his property. It may show what his property's worth, but that doesn't show the value of his property. So the bottom line is, Mr. Gunn hadn't showed any reason why the city would be responsible for maintaining his private property. He hasn't showed that the city owned and controlled this on his private property. And then the biggest thing, like I said, there's no proof whatsoever to show that anything that the city did resulted in the collapse. And as I mentioned at trial too, Mr. Gunn always wants to talk about the fact that he didn't do anything to this drainage structure. That's probably a problem too. He's got a duty to maintain any drainage that he has on his property. It's not the city's responsibility to maintain his private property. Thank you.
Thank you. Mr. Gunn, you have 2 minutes, sir.
Maybe I make it too simple. I was taught torts by Dick Snow, and he made it real simple. The law would protect you if there was a duty, a breach of that duty, and resulting damages. Here we have a duty. The city built the dam wall. The city put the culvert in, the aluminum, the silver culvert. The city put the black plastic culvert in, and it didn't work. And it flooded. And when it flooded, it ate away at the dirt underneath the asphalt, and the asphalt caved in of the parking lot. So to me, maybe I'm too simple a lawyer. The city did every bit of that. I didn't do any of it. I never, in fact, they never asked me, could I do so-and-so? They just did it. So we have, the proof shows my tenant saw them do work. So there was a duty, they made the duty, and then they breached the duty, and then the resulting damages, I lost a parking lot. Thank you.
Thank you very much. We will get you an opinion as soon as possible. May call the next case.
State of Tennessee versus Isaiah